Scott coughed convulsively, swallowed hard, and continued. It would have made a heap of difference then. Now it don't seem to matter much. Not to me, anyway. Might make things a little better for Harriet, though. There are no formal documents concerning the brief interview held in 1854 between attorney Montgomery Blair and his new client, a slave of about 60 years, who was sure he would soon die of tuberculosis. Oral tradition, preserved in East St. Louis, Illinois, insists that Dred Scott had only the foggiest idea of what was meant by taking his case to the U.S. Supreme Court. That same tradition stresses, though, that Scott had one bright, burning hope. While freedom would mean little or nothing to him or his wife, it would make a difference for their two daughters. Yes, sir, I could die a happy man, he told the Kentucky-born attorney, if and only I could know that Liza and Lizzie would go free. Montgomery Blair, a longtime resident of St. Louis, had known of the Dred Scott case for years. Ardent abolitionist Henry Blow, a son of one of Scott's earlier owners, had dreamed of a sweeping legal victory that would set precedents and make lasting changes. Blow had hired attorneys to represent Scott in the lower courts. Now he was willing to pay court costs in order to get a definitive verdict from the U.S. Supreme Court. Blair agreed to represent Scott without fee. He already had substantial friends in Washington, and a Supreme Court victory on a key national issue would almost guarantee him a top appointment in the next administration. Besides, Blair told his friends and family, who questioned his judgment in providing free service, it is practically an open and shut case. Henry Blow has helped me to assemble Army records which show that Dred was a resident in free territory for maybe 5 years. That is enough to convince the High Court to set him free. Earlier, Blow had provided a capsule account of the illiterate slave's life. Dred was born somewhere in Virginia, a few years before or after the turn of the century, Blow said. He belonged to my father and went to Alabama with him. After nearly 20 years, they came here to St. Louis. At my father's death in 1832, Dred was sold to Dr. John Emerson, an Army surgeon. I never have been able to find out how he became tagged with the name Scott. Most slaves with surnames take them from their masters, and Dred was the property of my father the minute he was born. Anyway, he had become Dred Scott by the time he was taken to Illinois by Dr. Emerson. Later, the doctor spent quite a bit of time in Wisconsin. Old Army records prove that Emerson and his slave had lived in a free state and in a free territory for quite a while. It should be easy to get him freed, Henry Blow said. Blair agreed. Precedents are clear on this point, if no other, he said. I remember that when George Washington lived in Philadelphia as president, he brought some of his slaves with him. Because Philadelphia was free territory, Washington was afraid he might lose his favorite slave if he kept him there. So after he'd been in Philadelphia for about 5½ months, House. He sent the slave back to Mount Vernon for 2 or 3 weeks to prevent him from claiming his freedom. That cycle, Philadelphia to Mount Vernon, and then back to Philadelphia, continued as long as Washington lived in that city. Blair had read all the arguments and rulings in legal contests that had revolved around Dred Scott's freedom since Henry Blow first took action on his behalf in 1846. Missouri law had refused to consider residence in free territory in its decision, and the refusal of the U.S. Circuit Court in St. Louis to overrule had seemed to end the matter, until Blair decided to appeal to the U.S. Supreme Court 8 years later. Despite George Washington's slave and dozens of other presidents, the arguments before the High Court would have to be carefully prepared. High-powered advocates of the extension of slavery had almost unlimited funds, and they had retained 2 noted attorneys for John Sanford, the recent owner of Dred Scott. One was Henry S. Geyer, newly elected U.S. Senator from Missouri. The other, Reverdy Johnson, was the former U.S. Attorney General and former Senator from Maryland. Partisan leaders north and south believed the Dred Scott case could be used to strengthen their own positions. Both sides were sure of a victory. Pro-slavery forces counted on the Southern majority sitting on the High Court. Anti-slavery forces were confident that President, the U.S. Constitution, and the law were on their side. Arguments began in Washington on February 11th, 1856, and continued for 4 days. Justices conferred twice, reaching no decision, then adjourned for the month of March. When Horace Greeley's New York Tribune charged that the delay was part of a Southern plot, the Dred Scott case quickly became national news. Greeley was positive that the plot involved the upcoming presidential election in which the infant Republican Party was emerging as a power. Outspoken John McLean of Ohio, the only clear-cut abolitionist on the Supreme Court, hoped to be the Republican nominee. Should he be a lone dissenter in what was fast becoming the by others on his behalf. Scott was a slave, property, pure and simple, who could not be a citizen of any state. Hence, he could not sue anyone. The fate of the gray-haired slave who was dying of tuberculosis was settled once and for all. Then Danny added a series of additional rulings that, while not directly related to the case before the court, held that the act by which Congress had forbade slavery in northern territories was unconstitutional. A slave is property, the argument ran. Under the U.S. Constitution, no right is more clearly